Good morning, everyone. Hello, this is Joe Adams here. I'm a U.S. immigration lawyer who splits his time between Los Angeles and New York City. My practice is exclusively federal immigration. It's September 17th, 2025. It's 10 o'clock in the morning, East Coast time. We're here to talk about U.S. immigration. What are the challenges? What are the opportunities? What are we looking at for the rest of 2025 and into 2026? Obviously, immigration is on the top of everyone's mind right now. It's in the news like I've never seen it before. I've been practicing law for almost 20 years and focused on immigration for about 15. And even the challenges of COVID pale in comparison to the challenges before us. But what are the facts? What's the fiction? What's the truth? What are rumors? That's been such a big part of my job for many, many years, and even more so today. We have an administration that's openly hostile towards immigrant communities, broadly speaking. We have a federal bureaucracy that, even in the best of times, is not perfectly functional. And we have an immigration system, a legal framework that is sorely in need of an update and has been needing an update and reform for decades. Uh, all that being said, at the same time, what's going on the ground level? What am I seeing with my cases, with my clients who are pursuing their immigration options? And just for a bit of context, I was thinking in preparation for today, what can we look back on in the past as a point of comparison? It occurred to me there was a particular case that I handled back in 2020, late 2020, early 2021. So the early Biden administration. We had a case, and I'm going to share my screen so you could see the discussion that I'm offering, and I'll send you this link. Uh, I had a case involving a Grammy winner. This is a fellow who had won a Grammy Award for producing the album of the year, Adele's album, no less. Uh, by the way, the client here, Austin, gave me permission to discuss his case and write this article. So we're not talking about anything we shouldn't be talking about. In Austin's case, he had been in the United States for many years on an O1 category visa, won a Grammy. We filed his immigration case saying, hey, this is a special circumstance. There's a special section of the law for people who win major international awards. You could see back in early 2021, we filed his case. There's Austin, there's Adele up on stage collecting their Grammys. Oops, we get rid of that pop-up box. And the evidence in that case is not complicated. Here's his Grammy that he won in 2016, showing that he had won a major international award. Long story short, the government comes back and says, in a denial, the evidence doesn't show he received a major international prize or award. Uh, what the heck is the government doing? This is the government under the Biden administration. I thought the Biden administration was supposed to be helpful to immigrants and responsible and accountable. And here we have an immigration service in 2020, early 2021 that says, yeah, Mr. Judge Chandler, that's very nice that you won a Grammy, but you still haven't proven that you won a Grammy. So by comparison, where are we at today? With Austin's case, we took that denial, we took it to federal court, and very quickly the federal court reversed the Immigration Services denial, and Austin has his green card today, will be eligible to apply for citizenship soon. But the baseline that I'm trying to start at is we have a dysfunctional immigration system even in the best of times. Okay, so how does this new Trump administration compare in 2025 versus recent history? Well, I'll tell you, from my own perspective, we file a lot of cases for artists, entertainers, people in STEM, people in academia, scientists, people who are pursuing the extraordinary ability categories. We file a lot of cases under the O1 extraordinary ability standard for temporary work authorization, typically a 3-year term. And then we file a lot of EB1 extraordinary green card cases for people who also have an extraordinary ability, but who want to become permanent residents of the United States. So it's a very similar standard. It's an extraordinary ability standard, but the outcome is different in terms of the length. So an O1 visa, 3 years is the max per case. An EB1 green card is permanent residency in the United States. How does 2024 compare to 2025? So 2024, last year of the Biden administration, we had 5 really tough cases where the government pushed back and said, we just don't think this person meets the standard. So I'm not including cases where we filed the case and the government just approved it, no questions asked. I'm not including cases where the government came back and said, oh, we just want more detail on your itinerary, or maybe we want you to go to an outside agency for an opinion. Those are simple pushback. That's a simple request for evidence. In 2024, we had 5 tough ones. We pushed back on all 5. We won 4 of the 5. And we're about to go to a similar stat here in 2025. We just won a major request for further evidence 2 weeks ago, a very challenging one where the government said, we just don't think this person has the high level we're looking for. And we were able to turn that pushback into an approval. So from where I'm sitting, I'm not practicing law any differently in 2025 as I was in 2024. We're analyzing people's factual scenarios and their goals. We're aligning their goals and the facts to what possible choices they have in terms of an immigration proceeding. We're filing cases with the Immigration Service. We're having sort of typical, bureaucratic issues with governments. Sometimes they're slow. Sometimes they miss out on things. They overlook evidence. They misapply the law. That's normal. I wish it wasn't, but that's normal. Am I getting people turned away at the border? No. Am I getting people just minding their own business at home and people knocking on the door and asking questions? I don't have anything like that to report. So despite all of the churn and chaos in the news, and my heart goes out to the people who are being targeted by ICE and Customs and Border Patrol, I'm not seeing it with my clients. So I want that information to come across that if you're considering pursuing a U.S. immigration option, there's been no substantive rule change that at least is affecting my clients. One thing I do want to bring up, and I do want to get to your questions. I see some coming in. Please put your questions into the chat. Or into the Q&A. I will do my best to get to everyone's questions. If you have to leave early, rest assured I'll send a recording of this video to everyone who signed up. So put your questions in the chat, but I do want to bring up another subject. There was a rule change that I wanted to address. Let me share my screen with you so you can see what I'm talking about. So there was a rule change at the State Department level. So remember, the way most people get their work-based visas is they file a petition with USCIS. This is what we refer to as petition-based applications. We file a petition with the Immigration Service here in the United States. If the Immigration Service approves the petition on its merits, they think you meet the extraordinary ability standard for an O1 visa. They agree that you're doing an intra-company transfer through a multinational company. That's an L1 visa. Or if you're a technical worker on an H1B visa, these are all petition-based applications. We file the petition with the processing office. Then the beneficiary, the foreign national, goes to a U.S. embassy or consulate. Up until recently, somewhere in the world, a U.S. embassy or consulate for a short interview. The purpose of the interview is to screen for fraud and what we call inadmissibility. Inadmissibility is a broad concept. criminal histories, gang affiliation, terror group affiliation, those kinds of very serious issues, not the substance of the case, not does the person meet the standard, did the company file paperwork showing that it was qualified to sponsor the case, but questions like, should this person be allowed into the United States? Up until recently, we had what's called third country national processing. So that meant, and I have some examples of what third country processing is. Let me just read them to you to give you some examples. Albert's a citizen of the United Kingdom who lives in Los Angeles. Say he was in the United States on an O1 category visa. Say he's a musician. He filed for an extension of his U.S. visa in 2024, and he hasn't left the United States since. He plans to go to Mexico for a friend's wedding in October. Under the prior TCN, Third Country National Processing Rule, Albert could process the new visa at the U.S. consulate in Mexico. Maybe he's going to Mexico City, he could go there. Maybe he's going to Tijuana, he could go there, and then return directly to the U.S., directly from Mexico. Under the rule change, now he has to go to the United Kingdom. He has to go all the way back, say, to London to have that short interview to obtain his visa before he comes back to the United States. So under the new rule, the U.S. consulate or the U.S. embassy in Mexico will say, no, Albert, you're a British national. You have to go back to the United Kingdom. Example B, Bharat is a citizen of India, and he's been working in Canada. Okay, maybe he has a temporary work visa in Canada. His employer filed an I-129 requesting non-immigrant classification, say an O1 visa or an H-1B visa, and that was approved. Under the prior rule, Bharat could have gone to an interview at the U.S. consulate in Canada, Vancouver, Toronto, Montreal, etc., and attend his interview there. Now he has to go back to India to do this. That is the new rule. The substance of the rules haven't changed. So the same interview should take place in London, in Delhi, in Vancouver, in Mexico City, but they're operating out of the same rule book. It's just about scheduling and who gets scheduled. I'm frustrated, obviously, with this kind of rule change because this is adding an additional expense and additional time and stress for people who don't need it. I expect the government announced this rule over a weekend, about 2 weekends ago. They had no prior consultation with the business community, no prior engagement with tech, with finance, with art, with culture. They had no participation from our communities. And I expect that the business community, well, I know that the business community is up in arms about this because it adds extra expense and extra stress to their workers. So I would hope that this rule will change back to the old status very soon. We've seen this before with the Trump administration, announcing suddenly a new policy, getting negative feedback from the business community, and then reversing course. I hope that that's what happens here. And at least for now, that's the rule change that is directly affecting my people. We've got a few questions coming in. Let me answer this one first. Does your office do profile evaluations? I'm always happy to speak with people about their potential cases. I tend to review cases and put them into one of three buckets. If you have a plausible case, if you have an implausible case, or if your case should be approved per se. It's unusual that I have that kind of analysis. What I like to do is sit down with the person, review their background, review what their goals are, and see what potential pathways might be available to them. Sometimes people don't have all the elements they need in order to pursue an immigration status in the present time, but we can lay out a pathway so that in the future they can aim their career, aim their objectives towards an eventual application of some type. I'm always happy to do that. I don't charge for a first consultation. I've been doing this for a long time, and I work mostly on referral. Uh, so I'm about building relationships with people over sometimes a very long period of time. Um, so I've been doing this for about 15 years. So, some of my clients have been with me for that whole time through all sorts of ups and downs in their lives, and losing a parent and getting married and buying their first house and having children and all the things that come along with that in terms of immigration. The next question from Josh, EB1A priority date. I'm glad you're bringing this up. This is something I plan to discuss in today's session. So maybe, Josh, we could use your facts as an example. I'm an Indian passport holder having an approved EB1A with a priority date of June 5th, 2025. Okay, so I already know that Josh has been deemed to be a person of extraordinary ability. It looks like he filed his case rather recently. If he used premium processing, he would have filed it probably in January, February, maybe spring of 25. If he was standard processing without the expedite, probably filed it in 2024. I wanted to know, what is the guesstimated timeline I'm looking at for my visa application, interview processing, and stamping from the NVC, National Visa Center, and the U.S. Consulate. At present, my case is transferred from USCIS to NVC after approval. So let me explain to people thank you for your question, Josh. This is exactly what I wanted to talk about today. Let me explain to people what some of this is, because some people may not be familiar with the concepts of priority dates, the National Visa Center, et cetera. I'm going to share a document with you called the Visa Bulletin. I do not even like the name of this document because I think the jargon gets a little confusing. So this is a document that the U.S. State Department maintains. Every single month, the State Department updates this document based on the prior month's green card usage. So the Visa Bulletin is about green cards. It's about lawful permanent residence in the United States. So when people talk about immigrant visas, or they talk about lawful permanent residence, or they talk about green cards, no, they're all talking, it's the same thing. Green card is just a slang term referring to the old physical color of the ink that they used to use. I guess green ink was hard to manufacture in the 1920s, 1930s, so they used green ink to prevent fraud. That stuck. Obviously, the green cards today are printed on plastic. They look like a credit card. They have all sorts of security features, a magnetic strip with biographical information in the strip, but they're still printed in green colored ink. Immigrant visa as opposed to non-immigrant visa. So an immigrant visa is when a person comes to the United States and they say, I plan to make the US my home on a permanent basis. A non-immigrant visa is where a person comes to the border and they say, I don't plan to make the US my home on a permanent basis. Examples of a non-immigrant visa: a B1, B2 tourist visa, an F1 student visa. An immigrant visa, examples of an immigrant visa would be like a K1 fiance visa, or what's called a CR1, an immigrant visa based on marriage to a U.S. citizen obtained outside of the U.S. at a U.S. embassy or consulate. And then some visas are what we call dual intent. An O1 visa is a dual intent. H1B, L1 are all what we call dual intent, where the government doesn't care if you have an immigrant intent or a non-immigrant intent. Okay. So that's what this document is. This is called the Visa Bulletin, and this document's updated every month. 650,000 green cards get issued per year. That's it. That's set by Congress. So when Trump goes out there and says in the political campaign last year that he was going to give a green card to everyone who graduated from a four-year university, there's been no proposal. There's been no legislation. He said it once and then never brought it up again. So when I get phone calls still to this day, which I do, saying, hey, Joe, I'm about to graduate. Where's my visa? Where's my green card that Trump promised me? There's no green card. There's 650,000. Congress allocates who gets them. They're determined by percentages, but no country can get more than 7% of the total. So that puts a disadvantage to people from big population countries like India and China. uh, uh, the other point I wanted to make about Trump, he was talking about the golden visa. You know, he wants to market it as the golden visa, where you give $5 million to the government, and in exchange for the $5 million, you get a green card. That's not, there's no proposal, there's no legislation, nothing's been done. It's something he said. I know that there are people out there who are scamming people, who are saying, give me that $5 million and I'll get you to the front of the line. There is no line because there's no proposal, there's no legislation. Only Congress can decide who gets these visas, who gets these immigrant visas, and under what terms. And Congress has passed no law. And it's not as if there are extra green cards just sitting out there that Trump gets to allocate. You know, every year the government uses the 650,000 max green cards, and if they don't, they get sued by lawyers and non-governmental organizations and universities because we want the government to allocate all 650,000 to clear our backlog. So that comes up to the point of Visa Bulletin. Every month, around the middle of the month, the next month's Visa Bulletin's announced. So right now, the October Visa Bulletin was just announced, and there were some important changes. So pulling up the October Visa Bulletin, you could see it for yourself. I'll send a link to everyone who signed up so you could look at it for yourself. The upper section is family-based immigration. The lower section is employment-based immigration, employment-based EB, like EB1. So let's scroll past the family-based sections. Family-based has 4 categories, but one of the categories is subdivided. So it's effectively 5 categories based on your family relationship. So you say you have a U.S. citizen, brother or sister. Say you have a U.S. citizen brother or sister, that U.S. citizen brother or sister could sponsor their foreign national brother or sister under an F4 category. The way you do that is you file a document called an I-130 and I-130. Not a controversial document, but it's how you get your place in line. You pull the ticket, you know, think of it like an old-fashioned Jewish deli. You pull the ticket, and then you have to wait for your turn to get called at the counter. If you don't pull the ticket, they're not calling your number. You're not getting what you want. So fourth preference category, brothers and sisters, you pull the ticket by filing your I-130, your U.S. citizen brother or sister does, and then you have to wait for your ticket to be called. Well, there's a lot of people ahead of you in line for F4. We scroll down to F4. I usually like to use the F4 as an example because it's pretty simple. That I-130 based on a brother or sister, the facts there aren't complicated. It's a simple filing. F4. Now, here's how you read this chart. If you were born in China, India, Mexico, or the Philippines, you're in those columns to the right. If you were born in any other country in the world aside from China, India, Mexico, or Philippines, you're in the all chargeability areas except those listed. Why is China, India, Mexico, Philippines separated out? Because no country gets more than 7%. So in family-based, China, India, Mexico, Philippines have hit that 7% mark consistently, so they're separated out. Everyone else is in all chargeability areas except those listed. Sometimes people refer to this column as ROW for rest of world. So if you see people talking about the ROW, they're talking about this column, which the government calls all chargeability areas except those listed. So if your U.S. citizen brother or sister filed the I-130 way back before January 8th, 2008, only now can you go through the next step of the process, which our friend mentioned was consular processing. If the person's in the U.S. and in status, they could file for what's called adjustment of status. If they're from China, same deal. But then if they're from India, look here, Mexico. If we just celebrated the 24th anniversary of 9/11, if you filed your case before 9/11, only now can your Mexican brother or sister go through the next step of the process. So family-based immigration has their chart. Now let's look down to employment-based. Employment-based has 5 categories. EB1, EB2, EB3, EB4, EB5. Some of you will know EB2 is divided into two subcategories. EB2s that are sponsored by employers, where they get a permanent labor certification. Those are what we call perm cases. And then there's a different flavor of EB2 called EB2 National Interest Waiver, where we show that it's in the national interest to waive the labor certification requirement. A lot of people from India have filed EB2s over the years, showing that it's in the national interest of the US government to waive the labor certification, but they're stuck. And let me show you why. So if we scroll down here again, ROW, China, India, Mexico, Philippines, EB1, all chargeabilities except those listed. So every country in the world, it has that C behind it. C means current. C means there is no delay. You pull your ticket, you get your sandwich instantaneously. You pull your, for our friend who just got his EB1A approved, he filed his EB1. He has a priority date in 2025. If he was from any country except China or India, he could immediately go through the second and final step of the process, which is to go through the consulate, through the U.S. National Visa Center, and attend his interview at the U.S. consulate in India. Or if he was in the United States and in status, he could immediately file for adjustment of status. But he was born in India. And so because of that, I'm going to throw a fancy term at you. This is what's called retrogression. The EB1 category, just like the brother and sister category for everyone, is retrogressed. You could also see China is retrogressed. But now look how bad it gets for people with EB2s. For EB2s, either perm cases or national interest waiver cases, well, for the rest of the world, December of 23, okay, you've got a wait time. China born April of 21, Mexico December 23, Philippines December of 23. But look how bad it is for people from India. If you were born in India and you filed your EB2 NIW case before April of 2013, only now can you go through the next step of the process, consular processing or adjustment of status. But look how much improvement there is for EB1. So a lot of Indian nationals are considering preserving their priority date. You can preserve your priority date. Maybe you have a 2018 priority date. So you're not current for EB2 NIW, but you would be current for EB1 if the government approves your EB1. So again, like the family-based case, we don't file an I-130, we file an I-140. The substance is a lot more complicated and subjective for EB1 and for EB2 as compared to, say, are you the brother or sister of a U.S. citizen? That's a very easy case. EB1 is about showing extraordinary ability. There's a series of 10 factors, or showing that you win a major international award. EB2 NIW is about showing that it's in the national interest to waive the labor certification requirement. There's a controlling case called Matter of Danazar, and if anyone's interested in discussing Matter of Danazar, we certainly can. There's another. So I'm going to finish that discussion. If anyone has any other questions about priority dates, when the question of when will my priority date become current? I don't know. Josh, I wish I had a crystal ball. There was major improvement between the August and September, between the September and October EB1 priority dates for Indian nationals. I don't know how it will change in the future. I'm hopeful. I have a few clients stuck in exactly your position who have 2023 and 2024 priority dates. So I would hope that in the next 2-3 years, maybe, Josh, that your priority date will become current. In the meantime, you've been approved for an EB1. That means, in my mind, that you've been deemed to be a person of extraordinary ability. If you want work authorization to live and work in the United States, I would strongly consider you reviewing an O1 visa. There are two flavors of O1 visas, O1As and O1Bs. O1As are for scientists, STEM professionals, athletes, licensed professionals like doctors and lawyers, and then O1Bs are for artists, entertainers, people in film and television. So if you're interested in discussing a potential O1 case, I'd be happy to chat with you further about that. Because for my Indian clients right now who are in retrogression, who have an approved I-140, but their priority date is not current, they have all of them have O1 visas that allow them to live and work in the United States. Okay, Carolina has a question. My appeal case, excuse me, let me see. I'll answer this live. My appeal case for EB1 was turned in my favor in March, okay, and nothing until now, nothing is reflecting on my I-140 that was denied in December. I asked Congressman to help and requested an expedite request, but USCIS refused and said that till now, no officer is scheduled for review. This is a very unusual situation. I already passed the time with work authorization and still waiting for reopening my I-140 without work permit and lost job. This is a terrible situation. If I don't get my new work permit, I will permanently lose my job and 180 days will expire in 3 months. What do I do to make them reflect the decision of appeal from March? I can't legally work, and I'm afraid I'll have to work to go back to my country without any status. I've had an O1 visa from 2006 till now, July 24th. Carolina, I am so sorry to hear that you're going through this. So the way I understand your scenario, you had filed an I-140, you had filed requesting an EB1. The government would have issued a request for further evidence where they say, we don't want to approve this I-140, this EB1. You would have responded and the government would have denied. Then you or your lawyer would have filed an appeal. Now, there are two kinds of appeals. One appeal is to the AAO, the Administrative Appeals Office. That is a department within the Immigration Service. I don't know if you filed an appeal with the AAO or if you filed a lawsuit with the federal. Yeah, you're just saying right now it's AAO. To just finish the thought, the other way to appeal is to file a lawsuit against the government in federal court. Which is what I typically do. When I started the conversation talking about Austin's case, which was denied ridiculously, we didn't go to the AAO. We went directly to federal court. This is an absurd scenario. So you're saying that the AAO has overturned the denial, and but they haven't acted. USCIS hasn't acted on the AAO. You've asked your congressman for help. USCIS refused. I would consider filing a lawsuit against the government. When the government fails to do its job, there are laws called the Administrative Appeals Act and something called the Mandamus Act, where we can go into federal court. The federal court has jurisdiction over the Immigration Service and can order the Immigration Service to take an action or to not take an action. If the AAO has overturned the denial on appeal and the Immigration Service is ignoring the AAO's order, that to me sounds like that they're not doing their job, and that the government could be compelled. One thing I like about going to federal court as opposed to going to the AAO, remember the AAO is within the Immigration Service. They are not under any particular time frame. They could sit on your appeal for months or a year or multiple years. In federal court, when you sue the federal court, there's a timer that starts running, a 60-day timer. From the day that you serve the lawsuit papers on the government gets 60 days to respond. We can agree, the lawyers can agree to extend that time frame by 15 days. That's it. And then the government has to respond to the lawsuit. So in Austin's case, I had filed that lawsuit, served it on the government, and within the 60 days, the U.S. Attorney's Office, who never had heard about our case before, got into the Immigration Service, reviewed the file, and before they even had to file something with court, reversed the decision, reopened the case, and approved. So it sounds to me like you've got some immigration officer who doesn't know what they're doing. How much would it cost, Carolina? Well, it depends on what a lawyer charges. The filing fee for a lawsuit in federal court is $402, if I'm not mistaken. So it's something that you would have to discuss with your lawyer. Some lawyers charge flat fees for this kind of work. Some charge based on how far the case goes, how deeply the government wants to dig in their heels, but most lawyers charge hourly rates. So it sounds to me like you've got a pretty good case for a mandamus action because the government's not listening to its own self. So I'm sorry to hear you're going through that trouble. That is just a ridiculous scenario. Um, okay, so that's where we're at in terms of changes to the rules. That's where we're at in terms of appeals. I did want to share a resource with you. Oops, I did want to share a resource with you. Um, Hold on one second. I hit the wrong button. Um, I wanted to share a resource with you. Um, so last year, as 2023 became 2024, the question on everyone's mind was, what happens if Trump comes back into office? And me being, a left-leaning person, I've been a registered Democrat my entire life. I said, there's no way Trump is coming back into office. The government, the people of the United States wouldn't make that decision again. It was such a rough time last time. And to reinforce that even if Trump came back into office, changing immigration law is very tough. The last time we had a big update to U.S. immigration law, I was a little kid in the 1990s, and I imagine many of you hadn't been born yet. So that discussion, that ongoing discussion that everyone wanted to have in early 2024, quickly led me to write a book. I wrote this book called Extraordinary Aliens: 12 People Who Pursued Wealth, Fame, and the American Dream. This is the cover. And I recorded a series of companion videos so I interviewed 12 different people of various nationalities, various backgrounds, who had come from very different walks of life, who could talk about what was the factor that made them think, I don't want to stay at home in India. I don't want to continue doing my career in Romania. I want to pursue my life in the United States. We sometimes in immigration talk about push and pull factors. A push factor is there's a war in my country. There's a prejudice towards people of my religious affiliation. There's violence against people of my gender or my sexual orientation. Those are push factors. If you don't have those concerns, what are the pull factors? What is pulling you to the United States? Economic opportunities, greater access to thought leaders, greater access to artistic endeavors. So I recorded these interviews, and they all have this styled yellow background, so you can see them. So these interviews are available on my YouTube channel. I'll put a link to you. And like I said, they're a diverse group of people. Here's one from Italy. Here's one from Japan. He's an actor. She's a filmmaker. Errol is from Bosnia Herzegovina, former Yugoslavia. He's a DJ. We have a lot of artists. We have some editors, some PR people. Mandeep is from India. He's a supply chain engineer. Navroop, also from India. She runs a think tank and is an expert in blockchain. So you've got a diverse group of thought out there. And then in the beginning of the book, I discussed the legislative history of the O1 visa and the EB1 green card. It came together very, very quickly. The legislation came together very, very quickly in the early 1990s. It was a time where the politics were less toxic than they are now. Um, uh, and uh, and that's what created these categories. These categories are not ideal; they're not perfect. The rules themselves are not written especially clearly, in my view. Uh, so uh, so that's what we've got. Uh, uh, so have a look at those resources if you'd like. Also, there's a resource that I'll direct you to as well. After I after I published the book, I thought, well, I want this conversation to keep going, and I want people to be able to ask their questions because you never know what new issue might come up, and rumors are constantly swirling, and information's constantly being pushed out there, correctly or incorrectly. So I created this subreddit uh, uh, called O1 Visas EB1 Green Cards. We've got about 3.1 thousand followers. I created this about a year ago. It's a very active group. The people I have found, the active participants are very courteous, eager to help. Um, uh, Obviously, we're not there to give legal advice. That's something that a lawyer does. But if people want to share news and information, a lot of people like to share their timelines. When did they start the process? When did they file? Did they use standard processing or premium processing? Did they get a request for evidence? What was the outcome? So those are some resources as well for you. And like I said, I'll send all the links in the email that will come later today with this recording. Josh is asking, is there a possibility of the Dignity Act of 2025 passing through the House and Senate and getting a presidential signature and approval? I think any legislation in immigration is going to be extremely challenging to pass. Regardless of what you think about the merits of the legislation, any immigration legislation is always fraught with a lot of politics. So we could point to specific areas of the law that probably 80 or 90% of the members of Congress could agree to change. But once you open that can of worms, once you unlock that door, uh, all the other constituencies will want to get a more comprehensive immigration reform bill. That's what we've seen for the last 2 decades, where some sort of trade-off for border security, some sort of trade-off for normalizing undocumented people's statuses, some sort of trade-off to address humanitarian issues. That's been the logjam. And in this particular political climate that's so toxic right now, I wouldn't imagine it will. Let's see. Hi, Joe. I've been in different types of visas since I got to the US. Currently, I'm under OPT, and the company I'm working with filed my O1 petition in August. My OPT will end on December, is how I read that. Looks like there's a typo. The problem I'm concerned about is the company is not doing well, and there are rumors about the company going bankruptcy. What will happen to my case in this situation? Unfortunately, this is a scenario that is somewhat common. If your petitioner ceases to exist or your relationship with the petitioner ends, I would never want someone attempting entry into the US on that status. And because that could be seen as misrepresentation, and the visa would automatically end. So, say for instance, you're currently in the U.S. on an OPT. For people who don't know what an OPT is, that's a work permit that follows a course of academic study. So, say you were in the U.S. on an F1 student visa. You then applied for an OPT, optional practical training, a work permit that follows a course of study. Then your employer filed for an O1 in August. Here we are in September. If the company goes bankrupt, that will put an end to the case. I'd be happy to chat with you about what your options are, but you need to be concerned about that because it can happen very quickly. Let's see. Forgot to mention that my goal will be having a green card eventually. I don't know if EB3 would be a good option. I don't know either. I think anyone who's been approved for an O1 and anyone who's been approved for an O1 has been deemed to be a person of extraordinary ability. What's the difference between a person who's been approved for as an O1 person of extraordinary ability versus a person who's been approved as an EB1 person of extraordinary ability? I think you'd be very hard pressed to find a concrete difference. Now, there are people who file an O1 case and an EB1 case simultaneously based on the same evidence, and I've seen it happen where the O1 gets approved and the EB1 gets denied on the same facts, on the same evidence. Different immigration officers looking at the same file can come up with different outcomes. That's part of the nature of the beast. It's a feature, not a bug. I wouldn't look to EB3 because as you saw with those priority dates, if there's a plausible case to be made that you are a person of extraordinary ability and you're saying to me that you're filing an O1 case, so someone's saying that you're a person of extraordinary ability for O1 purposes, I would look to EB1 first. And maybe you're not quite hitting the mark yet, but you could aim your career towards that because you saw how those priority dates are so retrogressed for EB3. And then finally, you said, can I change my status now? Should I wait? Let's chat privately about that. It sounds like a pretty specific kind of scenario. Unless anyone has any other questions, I would just thank you all for participating today. We've had some great questions today. I'm glad we chatted about these issues that are on the front of everyone's minds. I think that the key takeaways, there's nothing in my mind that is substantively different. There's nothing in my mind that is substantively different from the way I was practicing cases and practicing law in 2024 to now. We have to be persistent. We have to be optimistic. The way we get cases approved is through detailed preparation, through planning. That's how we get it done. Just a few little follow-ups. Carolina, yeah, I'm sick of the situation, scared. I agree with you. Why don't you contact me? And yeah, how do you contact me? If you registered for the webinar, I have your email. If you did not register for the webinar, my email address is Joe, at jaesq.com. Joe@jaesq.com. My phone number, my office phone number is 323-337-9012. Again, 323-337-9012. But if I have your email address because you registered, I'll send a recording and an email to everyone before the end of the day, and that will have all my contact information in as well. Thank you all so much for participating. Great questions, and have a great day. Bye-bye.